I did mention for obligation 49 my lord. My petition in custody more than 11 months, my lord. 49 my lord. Yes, ma'am. Okay. Does that? Hello.
Yeah, please, Lordship. Item number 33, PCR is not available, Lordship, and fixed and execution. 33.
33.
33.
PCR has not come.
But
Okay.
fixed and
Mr. M. Adam Pilan, to the petitioner submit that the record of the tribunal is not received. It will send a reminder. Concerned learned tribunal for the expeditiously send them to the report. List of, you will take after two.
Eight. Not published. My lord, made little Lordship. But if I wake up, upgrade my lord item 48. 48.
Okay, we'll see.
40.
I am due. I beg to mention item number 44, my lord. A matter may be taken after the motion, my lord. Petitioner behind bar, my lord, he is a mental patient, my lord. Treatment is going on under Tasco Mental Hospital. He is in detention. 44.
We will try to take it up as early as possible.
Yes. Obliged.
My lord, similar player in respect of item number 43, my item 43. 43. 43.
My lord,
If possible, my lord, the item may be upgraded.
try to.
But
Very please, Your Lord. I beg to mention also one matter was listed on 22 of this month, my lord. You know, so directed to file, my lord, eminent post title. So we have already filed yesterday.
By the time this order has been recalled, the another order has been uploaded that after you amend it, then it will come. Because I can't keep my orders not uploaded for more than 2 days. It doesn't happen in my,
Because we have filed on Monday. They are not accepting, saying that the file.
no, please try to understand.
Mm.
We are trying to facilitate the learned council just by passing an order that the amendment must take place. We have told you on that day also.
Yes.
That we can't have an order with a wrong cost title. And therefore, I was passing an order hitherto that the amendment should be made in the meanwhile, but it was not filed within time. And so therefore, if in my courtroom, or was it this courtroom, not my, this is your also. In this courtroom, if the orders are not uploaded within 2 days, it is flagged by my secretaries. My courtmaster will pester me that it's not been uploaded. So I have discontinued this system now. Now every order will be, it has to be amended first and then we pass an order. In the meantime, if any order has been passed, it is pending for more than 2 days, all orders have been recorded. It will be listed. I think your matter is listed on first. I don't know if I courtmaster will say. But orders have been uploaded yesterday.
Hello.
You can find out in the kiosk. It is uploaded.
Need please, Your Lordship. Lordship, I beg to mention item number 27, Your Lordship.
Item
27.
27.
Yes, Your Lordship. Lordship, kindly pass over the matter for the day.
It goes for 2 weeks. Okay.
Lordship, similar pair regarding item 30 and 39, Your Lordship. Similar pair regarding item 30 and 39.
30
Yes, Your Lordship. And 39.
and
39. 39.
Right.
Obliged.
may I please, Your Lordship, I'm paying from updating item number 51.
item
51. The petitioner's others and medical urgent.
Okay.
May I please, my lord? Let I get mental listing, my lord, in admission column.
Listen to the courtmaster.
May I please, Your Lordship? Lordship, I beg to mention for item number 4.
4.
Yes, Lordship. After 2 weeks.
Yes.
After 2 weeks. Lordship.
Your name?
R Khatun, on
I-
behalf R Khatun.
R. Mr. R. Khatun, and counsel appearing on behalf of Mr. M.U. Mandal, for the petitioner. Please do the matter be adjourned by 2 weeks. All the respondents are present. Matter can be adjourned to this coming 2 weeks.
Sir, please. That's why documentation item number 26 and 29. Lord. Into have to stop instruction from the petition.
26 and 29.
Come up after 1 week. Lord.
It goes for 2 weeks. 26 and 20.
29. Oh,
Please, your lordship, I beg to mention to listing lordship. The matter has not been listed.
Give it to the court master.
Okay.
Daily list item 1 for motion.
May please, your lordship. As per order 22/7, my lord, the husband of the petitioner went and meet the.
I believe in the last order, we made it clear that it's not a bar for you to file an IA.
Yes, we have prepared it. He is coming on Monday, my lord, to sign the affidavit.
Okay,
So we're filing on Monday or Tuesday.
okay. Uh,
This matter can be closed at.
Ms. P. Berman, and counsel for the petitioner, submit that an interlocutory application has been filed for extension of bail. So accordingly, all the respondents are represented. According to the matter stands adjourned today, list the matter as and when interlocutory application is filed in connection with this writ petition.
An interlocutory application in main writ petition probably, madam. There is a writ petition pending, madam. In that case, they are pending.
Okay.
This may be closed, madam. This is habeas corpus petition.
Let it remain, it will come together with this. What is the writ petition number? WPC 46 of 18.
Yes.
List this matter along with WPC 46 of 2018 as and when this interlocutory applications.
Much obliged.
Item 2.
Made please, your lordship. It's a habeas corpus petition, my lord. Lordship will see, my lord, paragraph 16, my lord, page 11, my lord.
When,
Page 11, paragraph
when-
16, my lord.
who is the person who was apprehended?
My lord, Mohammed Farish, my lord, without following the due process of law, my lord.
This matter being a habeas corpus petition has come, but there is no synopsis in this writ. You have not filed any synopsis here. So therefore, we've not been able to understand.
Oh, I'm sorry, my lord.
It's okay.
I'm really sorry, my lord.
No, this is a case of NDPS.
Yes, case of NDPS, my lord. Here the person who was arrested, my lord, without following the, my lord, Article 21 of the Constitution of India, my lord. But although, my lord, to my understanding, my lord, if the arrest is vitiated, my lord, there is no question of bail, my lord. So therefore, my lord, this habeas corpus petition has been filed, my lord.
You see, ask the state to respond.
My lord.
Mr. Kyal, 1 week time, because this is a habeas corpus
10
petition,
days time. Okay, 7, actually.
because we know the
Not-
requirement of law.
habeas corpus, again. बातें आए तो
Mr. N.J. Dattal and counsel for the person, as well as Mr. S.C. Kyal, other standing counsel for the NCP, was presenting the respondent. Next, go. By filing this habeas corpus petition under Article 226 of the Constitution of India, the petitioner has projected that his arrest on 28/10/2023 was vitiated as the due process of law was not followed. First of it is projected that the grounds of arrest was not served on him.
Yes, page 18.
Next. Issue notice returnable on, give a date after 7 days.
7 days.
The 6th.
Right.
6/8/2025. Next. Requisite extra copy of this petition, as well as a soft copy thereof, be provided to the learned standing counsel for the respondent, just to enable him to obtain instructions. Next, based on in course of the day. Next, based on say 6/8, soft copy and a hard copy.
By within 2 days, but by tomorrow.
No, today,
Today itself.
because we are issuing notice of 7
Mal-
days.
mal- Today.
His period was 10 days, we are
Mal-
cutting it to 7.
Mal.
Item 3.
May I please, Your Lordship? In this case, Your Lordship, the father of the petitioner has been deported, Your Lordship. And the Deputy Inspector General of BSF Thubri has filed their affidavit, Your Lordship. Today, the case was fixed for instruction on my part, Your Lordship. Now, Your Lordship, on my part, where about the father of the petitioner is not known to me. Nothing has been conveyed to the family members of the petitioner that the person has been deported, Your Lordship. And one more thing, Your Lordship, one more aspect is that the affidavit filed with the DIG Lordship, BSF Thubri, Your Lordship, they also doesn't provide under what provision of law, Your Lordship, the person has been pushed back, Your Lordship. If Your Lordship kindly see the Annexus C portion, Your Lordship. It is Annexus C of the affidavit, Your Lordship, 39 page number, Your Lordship.
Yes.
One notification has been issued by Ministry of Home Affairs, Your Lordship, regarding the procedure of deportation of illegal Bangladeshi nationals and Rohingya regarding, Your Lordship. Here, Your Lordship, Your Lordship, kindly see, peruse the whole Annexus C, Your Lordship. One thing is very much clear, Your Lordship, one inquiry have to be conducted before sending a person or before pushing back a person. The pushing back, what is not there? The word pushing back is not there in their notification itself,
Usually
Your
used word.
Lordship.
But then, Ms. Bora,
Lordship.
perhaps we'll have to amend this to in terms of the disclosure made, because for the present,
Lordship.
the first prayer is to disclose the status that has been disclosed. The second prayer is to arrange to
Lordship,
allow the
Lordship,
petitioner to meet.
visitation, Lordship.
So
Lordship.
that is not possible, because if you have to meet, then there's the requirement of passport, visa, and all,
Lordship,
or whatever
Lordship.
requirement, whatever is the
I'll
protocol
file
between two
a
countries.
substitute petition challenging the deportation, Lordship. So, Lordship, that may be disposed of, Your Lordship. That may be disposed of, because this was the prayer is only confined to visitation right, and Your Lordship,
We close this with liberty to you, without prejudice to you, to agitate any right you have. That will be good.
Lordship, Lordship.
Ms. G. Paral and the counsel for the petitioner submits that though by virtue of an affidavit filed on behalf of the Border Security Board, it is projected that the father of the petitioner was pushed back to Bangladesh side from the area of responsibility of ad hoc GW 2503 battalion, BSF, under sector headquarter BSF, Dhubri, according to her, the manner in which the action was taken is not in accordance with law. Therefore, he prays that in the event the court is inclined to close this matter, to be given liberty to agitate the said issue. Next. You have heard all the respondents are there. Next. In view of the submission made by the learned counsel for the petitioner, as disclosure of whereabouts of the disclosure of the current status of the father of the petitioner has been disclosed, and insofar as the second player is concerned, said to require the procedure as established by law to visit the father of the petitioner. The court is inclined to close this late petition without prejudice to the right of the petitioner to agitate. And if any issue regarding the father of the petitioner, as the petitioner may be so advanced. Next, the devotee has declared above, as mentioned above, his repetitions has. It's just now. CGC, who is there? Mr. Adhikari. We'll just although we use some colloquial words, but use of those words may not be the instructions. Please come to page 42. Last two lines. At 9:1, please read that 9:1.
All state governments maintain initiatives that set up special task force in the state under the police of the state, needing to detect, identify before illegal immigrants from Bangladesh, Myanmar.
The word used in the affidavit of pushback is a loosely used word. Correct.
Item 5.
May I please, Your Honor?
Issue of maintainability will be kept open.
Okay.
Delay in filing the writ petition. The issue of maintainability will be kept open.
Worship, this is an ex parte order. And we do not know about this order. And last 1 month, police is run after me. Therefore, I inquired.
No, that is
Thereafter,
okay.
we
We are
get-
keeping it open. We are not dismissing your writ petition right now. We are keeping the issue open to be decided on the next date. We are issuing notice, but Esteemed Brother is telling that the issue will be kept open.
You are Mr. Ali.
Yeah, Ali.
Heard Muhammad M. Ali. Sorry, A. Ali.
Yeah, Ali.
Also heard Mr. J. Pine. Standing Counsel FP Matters. CGC. Mr. M. Adhikari. M.R. Adhikari. Learned CGSC. And ECI. ECI and Government. 3. Mr. P. Sharma for respondent number 3. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the ex parte order dated 9/4/2021, passed in FT case number 828 of 17 by the learned member Foreigners Tribunal 7th Kolkata, declaring the petitioner as a foreigner in the post 1971 stream. Issue notice returnable on returnable in 4 weeks. The issue of maintainability of the writ petition is kept open. Requisite copies of the writ petitioner be furnished to the learned counsel for the respondents within a period of 2 working days. Relevant records we call for from the concerned tribunal by usual process as well as by email in the following address. The prayer for bail shall be considered. on
Worship,
the
I may be
next written
protected.
availability. Huh?
I may be protected, but
21.
I pray
4
for
years.
it. Arrested and deported.
Huh?
I may not be arrested and deported.
We consider the bill on the next. In the meanwhile, if the petitioner, namely Meghjan Nessa, daughter of Abdul Sheikh, is apprehended, she shall not be deported out of the country without order of the court. Petitioner shall produce the certified copy of this order to the Superintendent of Police, Border
Borpeta.
District. Borpeta,
Yes, sir.
list of.
29/8. Obliged.
Item 6.
May I please, Your Lordship? My lord, the impinging opinion at page 71.
S.A. Ahmed.
Yes.
Heard Mr. S.A. Ahmed, learned counsel for the petition. Also heard J. Payan, learned counsel, any counsel for the FT methods. CGSC, Mr. M. R. Adhikari, CGSC. Other. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has impugned the opinion dated 19/10/2023, passed it FT case number FTG 558 of 2011, arising out of police inquiry number 427 of 2007 by the learned member Foreigners Tribunal in Jorhat, Assam. Issue notice returnable in 4 weeks. Same date.
29.
Requisite extra copies of the writ petition be furnished to the learned counsel for the respondents within 2 working days. Let the relevant records be called for from the concerned Foreigners Tribunal by usual process as well as by email on the following email address. Prayer for bail shall be considered on the next returnable date. In the meantime, if the petitioner, namely Bulbuli Begum alias Musammat Nureja Begum, daughter of late Abdul Qadir alias Abdul Ali, is apprehended, she shall not be deported out of the country without order of the court. Petitioner shall produce a certified copy of the order to the Superintendent of Police,
Gulaghat.
to bring the order to notice. No, list on.
Item 7.
7, my lord. The impugning opinion at page 70.
Heard Mr. S.A. Ahmed. By filing this writ petition, the petitioner has assailed the impugned opinion dated 27/2/2025, passed in FT case number FTG oblique 555 oblique 2011 and FT case number FTG oblique 1145 oblique 2011, arising out of police inquiry number 424 of 2007 and police inquiry number 67 of 2009 respectively by the learned member Foreigners Tribunal Jorhat, Assam. Issue notice returnable in 4 weeks. Requisite extra copies of the writ petition be furnished to learned counsel for the respondents within 2 working days. Let the relevant records be produced. Call for from the Foreigners Tribunal
Jorhat.
by usual process as well as email. Learned Tribunal Jorhat. Prayer for bail is opposed by the learned standing counsel for the FT matters. However, in view of the projection made in the writ petition, the court is inclined to grant bail to the petitioner, namely Jadhan Ali, alias Muhammad Jadhan Ali, son of late Abdul Qadir, by providing that if he has not already been detained in custody, he shall not be taken into custody and deported from the territory of India on condition that he shall appear before the Superintendent of Police Kolkata within 10 working days. Golaghat. I'm sorry. During the office hours and shall furnish a bail bond of ₹5,000 with one solvent surety of the like amount to the satisfaction of the said authority. Further, the Superintendent of Police, Border, Golaghat, is directed that on appearance of the petitioner within the period indicated above, the biometrics of the petitioner within the period the biometrics of the iris of the both eyes, fingerprints of both hands, and the photographs of the petitioner shall be obtained, whereafter he will be allowed to remain on bail. On his appearance before the Superintendent of Police, Border, Golaghat, as directed above, the said authority shall obtain necessary information and documentation as required under the rules from the petitioner for securing his presence. On the failure of the petitioner to appear before the Superintendent of Police, Border, Golaghat, the bail of the petitioner would stand lapse, list the matter after 4 weeks, and or on receipt of the records.
Obligement.
Item 8.
In fact, we are not satisfied with the explanation. It was dismissed for default in 2023. You have filed and now you say that the National Council was not aware of the listing.
Lordship.
It's 2 years.
Yes.
See, one council could have missed the matter, but there are several council.
Yes.
Then we also have this telegram where the cost list is pushed to your respective mobiles. You can have access to the cost list from the website. To that effect, there is no explanation at all. Mr. Payne,
Well, my lord, my submission is that in fact, my lord, this writ petition will be not maintainable because they could file restoration petition in the original writ petition.
oh, acha.
They could file because the pleading may be different. They may take different pleading in this case. But for that purpose, that matter may be, my lord, may not be pursued. So
You're
procedure-
right. You're right.
My lord, earlier one was my lord closed, my lord, not was dismissed for default.
So closed is a very soft word.
Not,
Closed will not have any other
Well,
meaning
liberty-
other than dismissed for default.
Lordship, liberty is there, my lord. Liberty to petitioner to approach again.
Your delay here is not actually 20 it was last time. 23, there are no listings in between, no pursuits of between.
Yes,
23 it is disputed.
yes,
You come down to 25.
my lord.
Only explanation, is council did not know.
Lord.
But explanation,
Unfortunately, it is happened. It's true, my lord.
You have a copy of the previous writ petition with you?
Oh, no, my lord, that was not an accident.
No. Do you have a copy with you? Please pass it on.
Yes, my lord.
Please pass it on.
you are R.K. Talukdar.
Care of my lord.
Heard. Mr. K. Rahman, learned counsel for the petitioner. Counsel. The earlier writ petition filed by the petitioner being WPC number 613 of 2020 was dismissed, was closed on 10/5/2023, taking into account the non-appearance of counsel for the petitioner on 2 occasions. However, liberty was granted to the petitioner to approach again, if so advised. By filing this writ petition under Article 226 of the Constitution of India, seeking to exercise such liberty as aforesaid, the petitioner has assailed the order dated 4/9/2019, passed by the learned member of the Foreigners Tribunal, Kamrup Rural, number 1 in GFT Rural case number 768 of 2017, arising out of reference IM within bracket DT case number 1606 of 1998, declaring the petitioner to be a foreigner of post 25/3/1971. Issue notice returnable in 4 weeks. Requisite extra copies of the writ petition be furnished to the learned counsel for the respondents within 2 working days. Let the relevant records be called for from the concerned Fairness Tribunal by usual process as well as by email at the following email address: the prayer for bail shall be considered on receipt of the tribunal's order. In the meantime, however, if the petitioner, namely Monwara Begum, wife of late Abdul Latif, is apprehended, she shall not be deported out of the country without orders of the court. Petitioner shall produce a certified copy of the order to the Superintendent of Police, Border, Kamrup, to bring the order to notice of the authority. Let's take it.
29.
The writ petition which was disposed of, 6/1/2020 may also be tagged along with this writ petition.
Records of WPC 613 of 2020 be tagged along.
Obliged.
Item 9.
Below the Lordship. Lordship into test 77 minute impin opinion minute. 77. By order dated 21/5/2024.
Heard Mr. A. Mubarak,
Lordship.
learned counsel for the petitioner. Baki counsel secretary. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed The opinion dated 21/5/2024 passed by the learned member Foreigners Tribunal, Court Nagaon, in FT number 334 of 2015, arising out of police reference, FT case number 328 of 50, declaring the petitioner as foreigner. Issue notice returnable on
29/8.
requisite extra copies of the writ petition be furnished to the learned counsel for the respondents within 2 working days. Relevant records be called for from the concerned foreigners tribunal by usual process as well as by email at the following email address. The prayer for bail shall be considered on receipt of the tribunal's record. In the meanwhile, if the petitioner Muhammad Hamida Khatun, daughter of Muhammad Amiruddin, is apprehended, she shall not be deported out of the country without order of the court. Petitioner shall produce a certified copy of the order to the Superintendent of Police, Border Nagaon, to bring the order to notice. List again.
Item 10.
May I please your lordship? Lordship, Interim opinion is at page number 102.
J. Sikdar.
J. Sikdar.
Or J.I. Sikdar. For the petitioner. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the impute order dated issue notice returnable in 4 weeks. Requisite extra copies of the writ petition be furnished to the counsel for the respondents within 2 working days. Relevant records be called for from the concerned foreigners tribunal by issuing usual process as well as by email at the following email address. The prayer for bail is opposed by the learned standing counsel for the FT matter. However, in view of the projection made in the writ petition, the court is inclined to grant bail to the petitioner, that is Lalchand Ali alias Lalchand Ali, son of late Kurban Ali, by providing that if he has not already been detained in custody, he shall not be taken into custody and deported from the territory of India on condition that he shall appear before the Superintendent of Police so and so within 10 days from today during the office hours and shall furnish a bail bond of ₹5,000 with one surety of the like amount to the satisfaction of the said authority. Further, the Superintendent of Police is directed that on appearance of the petitioner within the period indicated above, the biometrics of the iris of both the eyes, the fingerprints of both hands, and photographs of the petitioner shall be obtained, whereafter he shall be allowed to remain on bail. On her appearance before the Superintendent of Police, as directed above, on his appearance before the Superintendent of Police, as directed above, the said authority shall also obtain necessary information and documentation as required under the rules from the petitioner for securing his presence. On the failure of the petitioner to appear before the Superintendent of Police, the bail of the petitioner shall stand lapsed. List the matter after 4 weeks or on receipt of the tribunal.
Item 11.
May it please your lordship. Lordship, opinion dated is 11/1/2024, page 30, lordship. Page 30, lordship. 30. Yes.
You are SK Sakma?
A.K. Hajam, lordship.
AK. Heard Mr. AK Hajong for the petitioner. Also heard. Also heard Ms. A. Verma. Standing counsel for FT matters.
Yes, Lord.
CGSC, Mr. P. Sharma, CGSC. MR Adhikari. Not CGSC. MR Adhikari, CGSC. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the order dated 11/1/2024 issue notice returnable on
2090.
requisite extra copies of the writ petition be furnished to the learned counsel to the respondents. Let the relevant records be called for from the concerned foreigners tribunal by usual process as well as by email. Prayer for bail shall be considered on receipt of the tribunal's record. However, in the meantime,
I may be protected.
the petitioner is apprehended.
No.
He will not be deported without orders of this court. Petitioner will produce a certified copy of the order to the Superintendent of Police, Gojali, to bring the order to his.
Earlier it was Borpeta, lordship, now it is Bojali. It is reflected in the order, SP border Borpeta.
Borpeta.
Yes.
Let's be Borpeta. Border Borpeta.
Now it is Bojali, lordship. Yes.
I said Gojali. List on.
2090. Item 12.
Lordship, this is contested matter and opinion dated is 11/4/2025, lordship. Page 30, lordship.
Same.
Page 30, lordship, 30.
Heard Mr. A.K. Hajong, learned counsel for the petitioner. Respondents by filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the order dated 11/4/2025, page 34. Issue notice returnable within 4 weeks. Requisite extra copies of the writ petition be furnished to the counsel for the respondents within 2 working days. Let the records be called for from the concerned tribunal. The prayer for bail is opposed by the learned standing counsel for FT matter. However, in view of the projection made in the writ petition, the court is inclined to grant bail to the petitioner, namely Mazibur Rahman. On the failure of the petitioner to appear before the superintendent. Borpeta?
Borpeta.
Borpeta. The bail petitioner shall, the bail petition shall, the bail granted to the petitioner shall stand lapsed. List after 4 weeks or on receipt of the.
Item 13.
Lordship, item number 13, lordship, the legal aid counsel D Ghosh will appear through online. Lordship, this matter may pass over for timing. Or it may be fixed at 2 lots.
At two.
Obliged lots.
Item 14.
May I please, your lordship, matter may be passed on for the time being. Yeah.
Item 15.
My official lordship. Lordship, order at page 81. Order at page 81. Date of order is 24/2/2025.
You are Mr.
A. Ali, lordship.
Air. Heard Mr. A. Ali, learned counsel for the petitioner, respondent, applicable. By filing this writ petition, the petitioner has assailed the order dated 24/2/2025, page 81. Issue noted, returnable on 4 weeks. Requisite extra copies be served to the council for the respondent in a period within 2 days. Let the relevant records be called for by usual process and email. Prayer for bail is opposed by the learned counsel, standing counsel for the FT matters. However, in view of the projection made in the writ petition, this court is inclined to grant bail to the on failure of the petitioner. This is the matter after 4 weeks or on receipt of the papers.
Apply.
Item 16.
May I please, my lord? My lord, impugn order at page 54, my lord. Challenging the order dated 6/10/2022, my lord. Let subsequent that order, my lord, petitioner arrested on 28th of May, 2025. Yes, my lord.
Okay. Heard Mr. A. Hussain, learned counsel for the petitioner by filing this writ petition under Article 226 of the Constitution of India, the petitioner has impugned the order dated 6/10/2022. The order is a page 54. Issue notice returnable in 4 weeks. Requisite extra copies be furnished to the council of the respondents within 2 working days. Relevant records be called for from the concerned foreigners tribunal. It is stated that the petitioner has been arrested on, has been taken into custody on
Page 20.
28th of May 2025. And is lodged at detention center Gwalpara at Matia. Detention camp or a transit?
Detention,
It is Guwahati.
It's detention center, or it is
Your lordship,
transit camp.
transit
Camp.
transit camp Mathieu.
At the transit camp, Gwalpara at Matia. In view of the detention, the petitioner shall not be deported out of India without orders of the court.
yes, my lord.
That copy of the order of this copy produced before the.
Yes, lordship. We had Mathieu lordship transit camp.
For the superintendent of police,
No, lordship, it would be at the transit camp.
before the superintendent transit camp, Matia Borpeta.
Your lordship. Gwalpara.
अच्छा ये बोपेटा का पुत्र डिटेंशन सेंटर गोलपाड़ा लिस्ट ऑन
Yes.
Item 17,
May I please, your lordship? My lord, the opinion at page 85. my lord. The opinion dated 31/2025.
और Mr. S.A. Ahmed, counsel for the petitioner. The petitioner has assailed the opinion dated 31/2025, page 85. Issue notice returnable in 4 weeks. Requisite extra copies of the petition be furnished to the council for the respondents within a period of 2 working days. Relevant records be called for from the concerned tribunal by usual process as well as by email. The prayer for bail is opposed by the learned standing counsel for the FD matters. However, in view of the projection made in the writ petition, we are inclined to grant bail to the petitioner, namely
Samsul Haq.
this is the matter after 4 weeks or on receipt of records from the tribunal. Records to call for it. Bill, bill.
Not bail may be granted, ma'am. SP Sipsagon. Obligement.
Sipsagar.
Sipsagon. Obligement.
item 18,
May I please, Lord? Lordship, opinion, my lord, at page 17. Initially, my lord, in this case, only some age difference, my lord, and name. Otherwise, he is in the same village. And petitioner is 81 years of age. Only, my lord, age discrepancy is there. In the same village he is living since 65 till date.
Ms. Verma, 81 years.
Lordship may consider lordship.
Or Mr. K. Pina for the. By filing this requisition under Article 226 of the Constitution of India, the opinion dated 24/2024 has been assailed. Issue notice, returnable in 4 weeks. Requisite extra copies be furnished to the council for the respondents within 2 working days. Let the relevant records be called for. The prayer for bail has been objected to by the learned counsel for FT matters. In view of the projection made in the writ petition and on consideration of the age of the petition, this court is inclined to grant bail to the petitioner, namely so and so. Conditions. Failure to be. List the matter after 4 weeks.
Bail may be granted. SP Tezpur.
SPP.
I love this.
Item 19.
Your Lordship. My lord, the petitioner challenged the order that is page 78, my lord, operative portion. But it starts from page 70, my lord. The page 70, Lordship, would see here, it is said that the evidences adduced by the petitioner are not convincing or credible. The linkage failed, whereas in every public documents, my name with my father's names appears. Whose name appears in the voter list of 65, 70, etc. So, my lord, I have adduced 4 witnesses, including government witness. That was, my lord, that was the LDA, register office Nogao, in respect of land documents.
We consider all those on the
My
receipt
lord.
records. Heard Mr. M.U. Mahmood, learned counsel appearing for the petitioner. By filing this writ petition under Article 226 of the Constitution of India, the opinion dated 2/5/2024,
Page 70.
page 70, passed by Nogam. Issue notice returnable on returnable in 4 weeks, extra requisite copies. List on 19. Requisite extra copies of the writ petition be furnished to learned counsel for the respondents within 2 working days. Relevant records be called for. Prayer for bail shall be considered on receipt of the reports. In the meanwhile, if the petitioner, namely Muhammad Saidul Islam, son of late Jobed Ali, is apprehended, he shall not be deported out of the country without order of the court. Petitioner shall produce a certified copy of this order before the Superintendent of Police, Border, Nogam, to bring the order to notice of the same authority. List on 19.
Well, I have a large number of documents, so I hope that I will get the bail, my lord. But bail may kindly be given. Because
That- That will consider on the next date because this, there's a delay of more than 12 months, 14 months to come here.
no, 14 months, my lord, that is due to reasons that I have stated.
We'll consider
The
that,
reasons is that.
We are not
Lordship
digressing
would
from
say-
the regular process, Mr. Mahmood. We are not digressing from the regular process. Once is a delay of more than 1 year, you're not granting bail.
But it was not for me, the order was kept reserved. Much later it is announced, so it is interim
It's okay.
protection till the
Once we
next.
call for the records, if that is there, we'll consider your prayer for bail.
Oh, short that back I'll be fixed. 2 weeks.
2 weeks it will not come, records do not come in that short period. You have seen, we have had experience here. It doesn't come. Unnecessary. And this few days, there are disruptions also. Some difficulty.
Item 20.
May I please ask? Say ex parte order मिला. And the petitioner filed vacation petition मिला. That is also rejected by the 15/2/2025. 24.
Which page is the opinion?
Opinion is page 22 मिला. The petitioner is indigenous Assamese Muslim मिला.
Heard.
Maintainability should be kept open here, Lordship. Because it's a 21 order, Lordship. It is approached clearly now.
Keeping the issue of maintainability open. Issue notice returnable on issue notice returnable on 1st of September 2025. Requisite extra copies of the writ petition be furnished to the council for the respondents within 2 working days. Relevant records be called for from the concerned. List on IA 6. issue notice. Mr. A.M. Ahmed for the petitioner. Issue notice. Prayer for bill shall be considered on receipt of the records. Arrest policeman. The petitioner who has been arrested, who has been detained on
25/5/2025
shall not be reported without further order. Petitioner shall produce a
Matia Lordship.
Matia.
Matia.
Okay.
Transit can Matia.
petitioner shall produce a certified copy to the concerned authorities. List on 19.
19.
Item 21.
And 21, same, my lord, brother. Same order, my lord. Same, my lord, same family member. Page number 21, my lord, expert record. Same day arrested.
Petitioner will be Harish. So we put this.
Yes, ma'am. Same thing. Yes, I
Item 22.
22, my lord, here is only a date of expiry order is different, my lord. And he is also brother, my lord, same family member. Yes. A date of opinion 6/9/2024. Page 20. Okay.
Ms. Verma,
Yes,
Yes.
Lordship.
within a year.
Lordship.
It has been filed within a year from the opinion.
Yes, so interim will be granted, Lordship. That is what Lordship has said, three. The pattern has already been set. No, the paper. Lordship is. No, but,
Has no any objection
the
if granted
Lordship
bail.
not using, but if he's in transit camp, Lordship,
Gwalpara.
then it is difficult. Because Lordship, in all the other matters, still now, people who are in the transit camp or in the detention center, Lordship has not granted bail to anyone. So Lordship, let the records come, because, and then Lordship will, because there may be something else to it. We do not have an idea on, no instructions on that at all, Lordship.
No,
2 weeks we'll get the records, Lordship.
Miller, initially petitioner filed writ petition before this honorable court
25 or
to have a audience, the petitioner in the detention center, Miller. Accordingly, court allowed the petitioner's family member to audience the detainee, that is the petitioner's, Miller. And he is in detention center at Gwalpara, Miller, at present. Yes. Yes.
Lordship may give the protection, no deportation, but we will get the records, Lordship. If Lordship sets this precedent, then it will be for all the cases. Judgment instruction পাবো লাগিছে ন সেইটো আপোনালোকে ঘূৰি থাকিব You kind of like.
Heard Mr. A. M. Ahmed, learned counsel for the petitioner. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the ex parte order dated 6/9/2024, FT Dibrugarh, page 20, that's it. Issue notice returnable on 13/8/2025. Requisite extra copies of the writ petition be furnished to the counsel for the respondents within 2 working days. Within today itself. Let the relevant records be called for from the Foreigners Tribunal by usual process. We also request the learned counsel for the FT matters to obtain the records of so and so through the Home and Political B Department. By the next weeks. Prayer for bail shall be considered on the receipt of the records. Since the petitioner is already in detention, he shall not be deported without further orders of this court.
I have a short submission, Lordship. The proceeding had started in 2018 itself, Lordship. He appeared, filed his WS, and then after that, he consequently never appeared. So the records will reveal everything, Lordship. So his conduct has not been proper, and now because he has not appeared, the judgment was passed in 24. And after that, he has been arrested. So, Lordship, granting him protection also at this stage, or giving him getting the records early is not justified because of his conduct, Lordship. The 24, no, Lordship, his opinion is he was detained in 25, but his case is of 6/9 years, within a year.
In a year. Only detention will be,
He's in the detention, Lordship.
so we are,
Yes.
the deportation, we are,
Yeah, deportation, I have no thing, but expediting him and putting him first before others, there are many more people who have come now, Lordship, because this process has started.
Nobody stopped the tribunal. There was no injunction against the tribunal not to proceed. If the tribunal doesn't proceed for that, he can't be blamed. Every litigant wants to,
Come, Lordship, let
every litigant wants to delay.
examine and we'll also see, Lordship.
Out of 2 litigants, many cases, one party wants to delay. See that when the record comes.
Yes, Lordship.
we did not. I had to list along with.
Obliged.
Lordship has fixed a date,
13th.
13th August. Lordship, after 15th August, because now we will not get it. Neither Home and Political will be there. Independence Day is there, Lordship.
Suggested date.
After 20th, Lordship.
We make it 20 then because it's Wednesday. 20.
24, yeah.
Publish.
Time being item 14.
May I please allow you? My lord, this is my lord, ex parte judgment, my lord, page 39. He has, my lord, all records from 1966 onwards, my lord. But according to petitioner, my lord, he was not served notice. But,
No, but the opinion at page 40 says that notice was served at the, in the residence.
yes, my lord, but he is, my lord, denying, my lord,
That's
specifically.
okay. We'll consider it when the records come. For the time being, it's 23, we may not be inclined to grant bail.
He has stated, my lord, at paragraph 5, my lord.
We understand that, but
Yes,
still,
my lord.
2F has been complied, 3F has been complied.
Heard Mr. A.M. Borbuya, learned counsel for the petitioner. The phone is taking it. Issue note, by filing this repetition under Article 226, the order dated 17/7/2023. 39 of it. Is a sale. Issue notice returnable on
Any short date, my lord?
1/9, on 1/9. Requisite extra copies of the repetition be furnished to the learned counsel. Relevant records called for. Therefore, we will be considered. Let's see that.
Obviously, my lord, if resumption goes, my lord, with all respect, my lord, if notice is served, my lord, he will definitely come up. Perhaps there is something on it, and he has all, my lord, good records are there, my lord. The next I have.
Let the record.
Well, in the meantime, he may not be deported if arrested.
Yes. He put it on. In the meantime, if the petitioner, no deportation.
I think item number 13 also. That's here is free. If possible, we may take up this.
No.
Yes. 13 lots. Legal aid matter.
Deep level. I will.
Time being item 13.
May it pleases your lordships. My lord, impugn order is at page 32, lordship. It's a contested matter and impugn order dated 19/3/2025, lordship. Petitioner's parents' name appeared in the voters list of 1966, 70, 75 and continuously, lordship. Her name appeared along with her mother in the voters list of 1997, which I have annexed along with the writ petition, lordship, page 84, lordship. So, lordship, at this stage, I humbly pray for records may be called for, and lordship, if she may be protected, lordship.
Heard. Ms. P. Ghosh, legal aid counsel, appearing for the petitioner. Let's put him in the same. By filing this petition under Article 226 of the Constitution of India, the petitioner has faciled the opinion dated 19/3/2025. Issue notice returnable in full, returnable by first of September. Requisite extra copies be furnished to the learned counsel for the respondents within 2 working days. Relevant record called for. The prayer for bail is opposed by the learned counsel for the active matters. However, in view of the projection made in the petition, we are inclined to grant bail to the petitioner, namely page 3, page usual indictable. Failure to be list the matter on 4 weeks.
SP Border Lordship Sonitpur.
Maybe 5 minutes late
Lordship,
in-
I am protected, Lordship.
We have granted you bail.
Yes, Lordship.
We have granted you bail. Any
Yes,
objection?
deeply obliged, Lordship.
You have objection, I believe.
Deeply obliged. Deeply obliged, Lordship. Deeply obliged.
Supplementary item 52 for motion.
Your did you file your affidavit? Still not here? When? It is still not available. You are listing it on Friday then. Yes. You want 1 week's time. There's a calendar, you tell us a date. When do you want? Reply by August 8th. 6th. Both sides are represented. The affidavit in opposition filed by the state is not on record. So let the said affidavit be tagged with record. Next paragraph. On the prayer made by learned counsel for the petitioner, the matter stands adjourned to enable her to file affidavit in reply in the matter. Which she proposes to file on 6/8/2025, list on 8/8/2023.
Supply item 53.
But you have to address us on maintainability. This ex parte opinion 2017 is SL now. After 8 years. No, if there was an ex parte order within 1 month, you could file a review petition. That was not done. So why we should entertain a challenge which is become stale? Pardon, please repeat again. This reputation would not be maintainable. No, no. May not be necessary. This ex parte opinion at page 16 says it all. Pardon me? No, you see, if you had intention to file, please tell us why no review was filed within the time allowed. Para 7. If you would have come within time, we would have accepted it, but 2017, you are now saying that it's not there. Yes, Mr. Payne.
Admitted that, my lord, he appeared before the tribunal, taking time to file the case. It is their, my lord, statement. It is not the case that, well, my lord, he has no knowledge about the pendency of the case. Despite of knowing the fact, my lord, that there is a case pending and there is an opinion, my lord, after 8 years, he is coming to the deportation honorable court only because he has been detained now and there is a process of deportation. Had there been no deportation process, he would have never come, my lord. My lord, had there been no knowledge that no service was served, he didn't appear before the tribunal, he didn't know anything about the proceeding, then there was a different case, man. But it is the case where he has the knowledge, man. Despite of the knowledge, my lord, he didn't care about the opinion. But now when he is detained, and when there is a deportation proceeding, my lord, process, now he's coming with deportation.
I'm not including more. I'm left from the part of the, but it's a matter of citizenship. No. He's participated during the trial and lot of all the documents of his need in the Indian citizen of India. That may be considered. For the lapse of on the part of the petitioner, some was we cannot be denied.
That this honorable court has decided number of cases, my lord, due to lapses, the writ petitions are dismissed, my lord. Latest last judgment under this honorable court in WPC 2930/2025. Your lordship has decided on 16/7/2025. In this case, everything is good. My lord,
Pass order. That's it.
Upgraded item 49 for orders.
What you order? Kitchen class, 3 my lord, 11 months. Why for consider for 11 months. Very much. 2 9.
Ali, what is your explanation for the
My lord, order sheet part is dictated the petition only appear one day, which is found. There are thereafter was not finally a written specified for themselves.
what is the explanation for that?
My lord, it was, my lord, thereafter, my lord, due to COVID, there are 70. Now it was unable.
No, but your explanation is in paragraph 18 is unacceptable.
70.
That is unacceptable.
My lord,
We have not,
11 month in custody.
but on merit also we have to see that you have a case. You have come before the court after 2 years. And the, and the number of adjournment granted was more than sufficient. It is okay, but 13 adjournments were granted.
It was frustrated about the climate count. One day we should have pleasure, but up to all the day. We can step in the first part. Because I got because that and
But if, in a lighter note, if without instructions, the advocate is taking 13 adjournments, he deserves an award. I hardly know a lawyer who would appear for 13 dates without instructions.
the case was studied for. Okay. Setting up the detention period, my lord. Mr. Pai,
Well,
what do you say?
my lord, the first explanation what my learned friend has said, my lord, due to COVID pandemic, he could not appear. The COVID pandemic, my lord, the Honorable Apex Court has, in fact, this is, my lord, the said, from 15/3/2020 till 14/3/21, this was the, my lord, limitation period for COVID. This process, my lord, he this expertise opinion from page 37, it is evident that he is absent from 21/8/2021 onwards. This is much after the COVID pandemic. And Honorable Apex Court has said, filing of WS 90 days will be count from the date of 14/3/2021. That is the first issue, my lord. So this period, 21/8/2021 to my lord, 17/8/2022, this is nothing to do with COVID. Because it is the, my lord, direction of the Supreme Court that COVID period, my lord, this period will be counted, will be exempted for filing WS and etc. This period is from 15/3/2020 to 14/3/2021. And once again, I will submit, my lord, that it is not that case that he didn't have the knowledge. He had the knowledge, my lord. Had there been no knowledge, my lord, I could have accepted that I have come to know about the opinion just now, some days back, so I'm now approaching the petitionable court. It is not that case, my lord. It is the case where he had the knowledge. Deliberately, he didn't appear. He had the knowledge about the pendency of the case as well as of the opinion. And there is provision, as per law, my lord, there is a provision that he can file review for setting aside the expert order that he has not resorted. That is, your lordship will find it in Foreigners Tribunal Order 1964. Three C, my lord.
Please refer to the provision.
Provision, my lord, Foreigners Tribunal Order 1964, 3C, my lord.
Capital C.
Yes, ma'am. And the WS has, the entire proceeding has to be completed within the month of 2 months, within the period of 2 months, my lord. That is 3 subclause 3A subclause 35A, no, 3 subclause 14, my lord. Foreigners Tribunal Orders 1964, 3 subclause 14 says the Foreigners Tribunal shall dispose of the case within a period of 60 days of the receipt of the reference from the competent authority. Not even WS, man.
We'll examine the records and pass on.
Okay, but you order. My lord, I'm today 11th March.
No, we'll pass our orders. Today we'll pass it.
This COVID extension period, I have given a judgment of the Honorable Apex Court, my lord.
Mr. Ali, on the last occasion, you referred to a decision of Shefali Rani Das. You have a copy of that?
Perfect. 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 Perfect.
David? WPC closed it out. 6-8 of it. And last time Mr. G. Sharma relied on this Hondas, 2016 1 GLT. You have a copy of that?
Junali Das.
Hon, THAN, Hondas.
Expertise. What's in my kindly take to judgment of this number court matter? Another doubt.
Upgraded item 50.
Yes. Yes, Mr. Gautam.
Lord, on the last date, a report was called for from at the border of Israel. And we are giving protection that we are not required to appear before that court because it was not a condition of the earlier bail order.
Oh,
That is 1921.
Yes, Mr. Pai.
Dear Lord, I have not received the instruction, but can it be fixed after work? Well,
No, because it will be, what you call, we'll extend the interim order then.
Yes, till then, well,
Then we are taking it after 2 weeks because next week we have some
yes,
difficulties.
The court, your article pass order for fixing the main matter on 4th of August.
On
maybe
4th
on
of August.
yes, on that.
Okay, okay. Then we take it up on 4th of August.
It may be fun.
Both sides are represented. On the prayer made by Mr. J. Pang, non-extending counsel FT matter. This is the matter of 4th of August. Enabling him to obtain instructions. Interim orders passed earlier shall continue. Okay.
Upgraded item 51.
Yes, medical treatment.
Yes, doctor, he is undergoing treatment lot. It is the instruction. He is refusing to take medicine lot.
Just now.
His lordship, he is refusing to take medicine lordship. Please report to lordship.
From what we have understood it is,
Yes, lordship.
he is suffering from some mental condition.
Yes, lordship.
If he is suffering from mental condition, he will not be thinking like you and me.
Lordship.
He would be under some sort of distress.
Yes, Lord.
One of them may be refusal to take medicine or
Yes,
aggravated
Lord.
bodily condition.
Yes, Lord.
His refusal to take medicine would require more care, or
Yes, Lord. Yes,
do we keep him detained because he's refusing to take?
Lord.
Should be given more care.
Lordship. Lordship. I will take the instruction, Lordship. Day after tomorrow, Lordship may PC में attend.
The senior brother is saying if there is mental condition, he would require more treatment in a specialized psychiatric.
Yes, Lordship. Yes, Lord.
Perhaps will not be available in where he is now being held.
Yes, Lordship. This is from psychiatric OPD of Gwalpara Civil Hospital.
It is a OPD, but you require proper care.
Yes, Lord. Yes, Lord.
Not in your, not in the detention perhaps.
Lord.
In that case for medical conditions, it is allowed.
Maybe not.
Conditions would be put upon him.
Yes. Okay. Otherwise, Lordship may also direct the respondent to take proper care. Lordship.
No, we'll be
Yes.
ready to do it. But will they be able to do it? Does your what you call this transit camp
Yes, Lord.
has a full-fledged psychiatric ward?
No, I think no, Lordship. Then Lordship may pass the appropriate.
He has to be, if he's on low mental condition and he's diagnosed of F45
Yes.
and stomatoform.
Yes.
Stomatoform is again a mental health condition.
Yes.
So, Sharma,
Lordship.
assuming we grant bail, then he will have to present himself, he has to be presented before which, whether it will be police station or SP office, where it has it be produced?
Lordship concerned SP Lordship Karbi Anglong.
SP office, Karbi Anglong.
Karbi Anglong.
Right.
I agree. But Mr. R.C. Das, learned counsel for the applicant. This IA has been preferred by the applicant. Praying for bail to be granted to his father, namely Abdul Salam alias Abdus Salam, who is presently lodged in transit camp at Motia, Gwalpara. the father of the applicant was taken into custody on 24/5/2025 pursuant to the ex parte opinion dated 27/9/2023 passed by the learned member, Foreigners Tribunal Dipu, Karbi Anglong in FT case number 205 of 2009. Pursuant to the order dated 18/7/2025, the Learned Standing Council, FT Matters, has produced an instruction dated 21st of July 2025 containing the comments of the medical and health officer, Transit Camp Motia Gwalpara, which are to the effect that the father of the applicant is suffering from several ailments, one of them being somatoform disorder.
This would make you F1.
Which is one of the diseases which is a F40 also known as F45, also known as F45, which is a category in the International Classification of Diseases. This disorder is characterized by physical symptoms that suggest a mental condition and causes significant distress or impairment in social, occupational, and other areas of functioning. The report annexed to the instructions dated 21st of July 2025 by the medical and health officer of the transit camp also indicate that the patient is refusing to take medicine and is suffering from low mental state, loss of appetite, and looks very anxious. He also suffers from UTI with fatty liver and prostatomegaly grade 1. The Standing Council for FT Matters has opposed the prayer for bail on the grounds that the patient, that is the father of the applicant, is himself refusing to take medicine and being already declared a foreign national, he is required to be deported and the prayer for bail may be rejected. Having considered the rival contentions, and in view of the medical condition which is reflected with the report dated 21st of July 2025, we are inclined to grant bail to the father of the applicant, namely Abdul Salam alias Abdul Salam, on the following conditions. He has to appear every 15 days before the consent of court.
Yes.
Order? Happy. Happy. The I is disposed. Main case. The PCR have been received. Issue rule returnable copy. List the matter. After. For him. With commencing 18 August 2025. Mas-
Upgraded item 43 for admission.
They are in this case. Very now. Appeared to the tribunal, submitted detailed statement. I've done it up to one. Thereafter, it failed to complete the paper. Tried to publish to other applicants.
Which paragraph is your explanation? In this repetition, which paragraph is your explanation? For not presenting yourself for cross-examination?
15 years of it.
15.
They learn and different sessions, doing different. The file here. Jump.
You speak loudly, we are not hearing you.
Keeping opinion, matter, there are two wrong findings.
It is only with regard to the name. You are projecting that your name is Hasem, your brother's name is Hashem. That is the one. Your statement is very vague, very difficult to accept it. Because you have not stated about your conduct. You went to work somewhere, it's okay. But you then say that you don't say that you tried to contact him, your counsel. For contacting a counsel, you don't need a mobile for yourself. You could have called from somewhere else. You have not shown up, not informed about your conduct in making an attempt to meet your counsel. No, no. Pardon me, please repeat again. Please repeat again. We do not catch it. Please repeat again.
Original document. Not that it be declared as public. After filing. Indicate.
But the thinking will not help you. With the nature of explanation given, it's non-condonable. Once you don't say that, you see, you're not made two statements. Number one, you made any attempt to meet the lawyer. Number two, you don't say that within this 1 year, you never came out of the place of work. You work constantly for 1 year in that place. You have not come to a hometown. That also statement is not there. No, that's okay, but your conduct during the time when you, from the date you gave documents to your lawyer and then turned up now. There's no statement that I never come back home. I do work and I do work continuously for years together. I don't come to my home. I don't make contact with my any family member. Then no, but there must be some pleading of some worth. If there's no pleading, we can't manufacture a ground ourselves. Every day I wake and in my dream, I always dream that all the council appearing in my courtroom should become an MLA and MP. Every day I dream like that. I think very big of everyone. It doesn't happen every day when I come, I see you here. But I dream that you would be an MLA by now. A very big shot, very known man worldwide. Doesn't happen. Yes.
Lordship, para 2 is very much clear, Lordship, page 52.
Pardon me, where, please?
Of the impugned opinion, Lordship.
If you notice, impugned?
Page 52, Lordship.
Page?
52. This tribunal by order dated 30/11/2017 issued notice to the proceeding and the proceeding on receipt of notice appeared and filed a written statement along with documents on 14/2023. The proceeding has claimed that he is an Indian citizen by birth. Thereafter, on 18/9/2023, the proceeding has filed evidence on affidavit along with some exhibits, and this tribunal by order dated 18/9/2023 fixed the reference for cross-examination of DWs and further evidence, thereby fixing same on 2/11/2023. On 2/11/2023, at the prayer of the
learned counsel in presence of the proceedee, time was granted by this tribunal for cross-examination and further evidence, Lordship. And after that, Lordship, proceedee continuously remain absent, Lordship. And Lordship, only after his arrest, Lordship, proceedee wake up and approach the honorable court.
This now, this just looking at the record. Which paragraph was your explanation? Which paragraph in your repetition was the explanation? Paragraph 15.
Yes, Lordship, only after his after his arrest, Lordship, he wake up and approach this honorable court, Lordship. And Lordship, in this regard, Lordship, so many decisions have been passed by this honorable court, Lordship. And IU 2016 1 GLT 273, Lordship. Ayub Ali in bracket Muhammad and others versus Union of India and others. Just I am relying on para 16 what it says, Lordship. I am just reading. It's 2016 1 GLT 273. 2016 1 GLT 273. Ayub Ali in bracket MD and others. I'm just reading para 16, Lordship. Principle of national justice cannot be put into a straitjacket formula. It is more than 3 decades that the issue of influx of foreign nationals has been in public domain in the state of Assam. Process of determination of question of citizenship cannot be a one-way traffic, leaning only in favor of a person whose citizenship is doubted. Interest of the state also of paramount importance in that unabated influx has the potential to affect the integrity and sovereignty of the country. Citizenship of a person, no doubt, is a very valuable right and should be jealously guarded. However, if a person does not take steps for safeguarding his interests, he does so at his own peril. Right to fair hearing and principle of national justice cannot be permitted to lead to a farcical situation and to be an engine for defeating very object of identification and deportation of foreigners. The petitioners had known about the allegation against them that they are foreigners entering India with any valid documents at least from 2007, even ignoring the earlier part under IMDT Act from 1997. The petitioners all these years apparently did not take any steps to defend their rights in their court proceedings. In these circumstances, I am not inclined to grant any further opportunity to the petitioners as any such course of action according to the perception to the court would self-defeating, Lordship. Para 16, I am relying, Lordship. Here in this case also, Lordship, proceeded filed his written statement, and after filing written statement, proceeded continuously remain absent, Lordship. Yes. After receiving notice, he is not received by the brother. Evidence also filed, Lordship.
Your first voter list is in 2005. Is it? More? No.
It's not perfect.
Item 44 upgraded.
The, opinion is an ex parte opinion. What is your explanation? 7 and 8. Which page is your medical certificate? This medical documents you are showing before us, what is the diagnosis? Doesn't have any diagnosis. Page 56 says. No. Documents page 50, we are not worried about the original. But where is the diagnosis? 53.
from 2017 to 2024, Lordship, there is no prescription. Lordship.
Yeah, that's fine.
Huh? Oh. Huh?
বেয়া অবস্থা তো যদি মাথা পাগল না হয় হয়তো ডিটেনশন করার দিকদারি করবে প্রত্যেক মাসে ইনজেকশন in order to offer the oh na to the okay 625 625 625 12 last year 25 আচ্ছা 72 হয়ে গেল 72 72 না কোনটা করতে
This order dated 9/5/2024 has been assailed in the present writ petition Next. The records received from the learned tribunal have been perused. Next page. The learned counsel for the petitioner has referred to the documents the medical documents at Annexure 9 of the writ petition, which are certificates issued by the LGBRIMH Tejpur, and has submitted that the petitioner had been under treatment of the said institute from around 2014 onwards, and he had been diagnosed to be suffering from capital F 20 plus capital F 10.1. The learned counsel for the petitioner has also referred to the later medical documents which are of the year 2023 and 2024 and 2025 to submit that it was due to the medical condition of the petitioner that he had not been able to present himself for cross-examination, and thus he deserves an opportunity to present himself for cross-examination. Full stop. He has thus prayed for a remand of the matter to be given such opportunity. Mr. Sharma, learned counsel for the FT matters, on the other hand, has submitted that no such ground was taken before the learned tribunal to explain the absence of the writ petitioner, and therefore such a ground taken now does not deserve consideration. Mr. Sharma has also drawn attention to the fact that the documents submitted are not in continuity and therefore may not require consideration. Para. We have perused the records of the tribunal and also gone through the documents annexed to the writ petition. The documents annexed by the petitioner indicate that the diagnosis was one of F20 plus F10.1 and in psychiatry, F20 is the ICD code of schizophrenia and F10.1 is the ICD code for alcohol abuse. It falls within the broader category of mental and behavioral disorders due to use of alcohol. On a further perusal of the medical documents, it is seen that the documents indicate a train of consultation and treatment from the year 2014 onwards through 2016, 17, and the document at page 57 of the writ petition would indicate that the petitioner had also approached the Institute of Mental Health on 2010-2023 and later periods, which continued up to 27 to 202, sorry, 3/4/2025, 12/5/2025, 12/5/2025. From the order of the learned tribunal, it is seen that the absence of the petitioner was on 23/8/2023, 28/9/2023, 31/10/2023, 29/11/2023, and 24/1/2024, when the writ petitioner remained absent without steps and did not appear before the tribunal to allow himself to be cross-examined. It thus appears that the petitioner was indeed undergoing treatment for schizophrenia and alcohol abuse.
I have to leave to another court meeting.
And during the period when he was also facing the proceedings, and therefore it cannot be said that he was willfully or negligently abstaining from appearing before the tribunal for his cross-examination. He had in fact filed his written statement and also adduced written evidence by way of affidavit. Next panel. In view of the above and taking into consideration the medical condition of the petitioner, this court is of the considered opinion that the petitioner would deserve an opportunity to adduce or to face cross-examination so that the evidence led by him can be given due weightage while by the learned tribunal. In view of the above, it is directed that the petitioner in view of the above, we interfere with the order dated order dated 9/5/2024 passed by the Foreigners Tribunal 2nd Morigao, Assam in FT within bracket C 1090 of 2012 to the extent that it proceeded on a presumption that the absence of the petitioner would lead to nullifying his evidence. The matter is now remanded back to the tribunal to allow the petitioner to present himself for cross-examination, for facing cross-examination on or before deputy. Stop. On setting aside of the declaration of the petitioner as a foreign national as stated above, it is directed that the petitioner be released on bail on furnishing on bail of on bail of no. On bail of rupees 20,000 with two solvent sureties of the like amount. The rest conditions will.
Yes, Lordship.
On failure of appearance by the petitioner on or before so and so, the bail granted, the bail granted that automatically stand lapsed without further reference to the court. And the tribunal shall be free to pass such orders as may be deemed necessary. By treating the petitioner's absence by treating the petitioner by such orders as necessary if petitioner is found absent on form. The LCR may be sent back. But the TCR will be returned to the tribunal. Writ petition expedition. The writ petition is disposed of, allowing it to the extent as indicated above. I have to keep in view of the orders passed in the writ petition.
Mr. Bliss.
Lordship, in item 45, Lordship, a date may be given.